Now I'll give one more instance, which is extremely important instance. Article 253 deals with the treaties which the government of India may have with foreign countries. But kindly have a look at the proviso to Article 253. Provided that after the commencement of the constitutional application of Jammu and Kashmir Order 1954, no decision affecting the disposition of the state of Jammu and Kashmir shall be made by the government of India without the consent of the government of that state. What is being recognized?
Disposition.
What's being recognized here? This is what I'm saying.
What is meant by disposition actually?
Final disposition, which would mean in 1954, the government of India concurs with the government of Jammu and Kashmir that the final disposition of the state of Jammu and Kashmir has yet to take place.
No, decision. Disposition of the state. Sorry? What is meant by disposition actually?
Not settlement. Disposition means settlement. This is the recognition of that position which preceded enactment of Article 370.
It doesn't mean that all treaties will not apply to J&K. For instance, suppose the Universal Declaration of Human Rights or the Covenant on Civil and Political Rights, that would apply. Or say the Convention on the Elimination of Discrimination Against Women, that will all apply, right?
We're only on the point of the state's disposition.
The state's disposition.
Now, when we talk of state's disposition, I had already entered into instrument of accession. What does it mean that the state has yet to be disposed and will be done by Government of India only with the consent of the Government of Jammu and Kashmir? Where would it apply? This situation will apply where? This is concurred by both the governments. It's not unilateral action. I would submit this is the recognition of that this issue has an external dimension, which is recognized in this. It has an internal dimension, which is also recognized in this. And both went together with Article 370, clearly carve out a position that state of Jammu and Kashmir has a distinct position pending its disposition. So, the premises on which I am building up my case is this: that state of Jammu and Kashmir, as all judgments of this court show, has a special and a peculiar position. It is for the first time this court is called upon on a very important issue, whether this can, the way it has been got rid of, whether it could have been done like that. And that does not involve any issue of the procedure involved. It also involves the issue of power. Isn't it something which is basic to all the arguments raised before this court with regard to the power? The power of parliament, the power of president, the power of the government of the state, the power of the governor. The common theme in all these constitutional authorities is the power. And we're examining that issue, we're debating that issue, that something has been done, whether you had the power to do so. This is one. Second, how did you exercise that power? And if the exercise of the power is unconstitutional, then even if you have that power, the action will still have to be invalidated. This seems to be the theme of the whole thing. That ultimately, whether 370 by itself subserves the sovereignty, as I said, it does. But at the same time, the sovereignty is exercised by it from time to time by agreeing to all constitutional orders, passed 54 in number, how those constitutional orders were passed, how they are passed, and what is the effect of those is also an issue. Then also, what is it that we are claiming? We're only claiming constitutional autonomy, which has been taken away from us on 5th of August and 6th of August. Now, how do we get that constitutional autonomy back? Is by demonstrating to the court that what is that I had. If I had nothing, then what am I fighting for? It would be an unrealistic litigation, unworkable litigation. It will have no result at the end. Second would be I still had the constitutional autonomy, maybe little, maybe whatever it may be, as Honorable Justice Court observed, you are talking of a skeleton. Maybe it was a skeleton, but somebody still felt that skeleton was disturbing him, therefore he got rid of it. If it was a skeleton, leave it as it is. The way we were living prior to 4th of August 2019, that the things remain as they are. But then the thought of removing this skeleton, somebody must have thought somewhere that this skeleton must also go. But I am not on the question of this skeleton. I still had the power. Now let's see what was in the Constitution. what was the constitutional application order, in particular 1954? Why? Because it is that order which is amended from time to time. And then what was sought to be protected? Can I say something more, Millers? We are protecting, let's say, the individuals who live in the state of Jammu and Kashmir as permanent residents. Now that is protected under the Constitution as applied to us. I'm just saying that is protected. That was protected earlier also in terms of the notification of 1927. And interestingly, at that point of time, agitation was raised by a community, Millers. Unfortunately, they left us, and we owe a lot to that community because we were taught by that community. Anyway, that apart, they agitated because they were the educated class, and the king at that time would get people from Punjab and other areas. So they said, we need jobs. So they agitated, and that resulted in a notification of 1927 and restricted appointments to the permanent residents. That subsequently there was a notification 1932 that also restricted. Now, when that is protected, now it has protected for several reasons. One could be that, look here, it is meant for the jobs, it is meant for the acquisition of the properties. Second also could be that, look here, the state as it is, so the people who live there need to have some rights, some privileges as against others. So they all protection came, that's one. Number two, state itself. Keep the state intact, though we are three regions. We're Ladakh region, Kashmir region, and Jammu region. The Maharaja at that point of time thought that bring all the three regions together, and then we became a state. To protect the whole state. Now what has been done? It has been divided. The people are divided. The part of it is with Pakistan, the part of it is with China. About 2,000 kilometers are with China in Aksai Chan. Part of it is with Pakistan, and remaining part is here. We're getting sandwiched between all these forces which are applying in the state of Jammu and Kashmir. Now, by virtue of this, again, the people have been divided now. Now we're reduced to a union territory of only Jammu and Kashmir, and Ladakh has been separated from us. Somewhere, somebody, when they say how to make a law, somebody was asked, a lawyer who was involved in how to make it, he told him, you tell me the political decision, I will tell you the law. Law does not precede political decisions. First, some politics comes in, then the laws come. So looking at the laws as they have been framed, somebody took these decisions to make divisions and further divisions to our state. Now we are claiming a position which it was on 4th of August. We need to be reunited with all the three regions. We need to live as we used to live. And then, of course, over the passage of time, as the government of the state, as I'm not on the wisdom of that, rightly or wrongly, government of the state from time to time did give its concurrence to the application of various laws from time to time. But nevertheless, there were some fundamental laws to which they have not agreed in the 69 years. Now, for the first time, now this proviso which is added to Article 3, this continues as it is. Now, entry 97, your lordship just read. Entry 97 is the residual power of the Union Parliament. If any of the subject of legislation does not fall in all those 96 entries, but yet it will be covered by entry 97. It means it is open. If any legislation does not fall either in state list or concurrent list and is made by Parliament, it will fall in entry 97. When it is made applicable to us, it is made applicable to us in a specified manner. What is that specified manner? In 1985, the Parliament enacted Terrorist and Disruptive Activities Act, commonly known as TADA. That did not apply to us. The government at that point of time, I still remember 6th of June, 1985, it recommended to the government of India, please apply this entry 97, but restrict it to the matters which your lordship read just now, questioning the integration of the state, questioning the accession, so on and so forth. Please apply that entry. Accordingly, this entry came to be applied. It would imply that entry 97 as such, with widest possible power under entry 97, does not apply to the state of Jammu and Kashmir. It applies on a specified issue of a subject matter of a legislation. This, for example, I'm indicating another autonomy which I have. I have the autonomy of permanent residence. I had the autonomy of alteration of my state. I had the autonomy of final disposition. I had the autonomy of entry 97, then there are similar other entries, both in the concurrent list as well as the list 1. So I will give you a long list of the entries which apply to us with modifications. And those modifications carve out the constitutional position, the constitutional autonomy which the state enjoyed. Now, see another important thing. The laws of this country obviously give rights to the citizens of this country. That's in terms of the fundamental rights and so on and so forth under the Constitution and under various laws. Now, these laws come into conflict with some of the laws which were applicable in the state of Jammu and Kashmir. In order to protect those laws, what the president did in 1954 order, he incorporated a new article, that is 35A. Incorporated a new article, that is 35A. It is not in the Constitution of India. Obviously, it cannot be in the Constitution of India. It is in the presidential order of 1954. He carved out this Article 35A with the concurrence of the two governments, protecting the employment, the permanent residency, the scholarship. I will indicate that also to lordships. He protected that as well. Now, this protection, this kind of protection, Article 3, 253, entry 97, all these do indicate I still had constitutional autonomy. It is not that I was completely reduced to a skeleton. Maybe I was on oxygen, but I still was living. I still had that constitutional autonomy in terms of this constitutional position. And I continued with that. Whether this was rightly done or wrongly done, nobody is questioning that wisdom. I mean, that's entirely for the government of the state. And between them, not even the government of the state, but the council of the state. Now see, Parliament is excluded under Article 370. State legislature is also excluded under Article 370. It is the president, the governor, and the council of ministers. That is all. These three are there in Article 370. They can do, undo with the Constitution. And my lords, learned judges talk to each other is always mysterious to us. They don't share their views to us so that we can answer them.
It's the same way.
Positive, negative, or their response.
Sometimes the same way when lawyers talks that not necessarily everything is.
So, I'll just indicate to your lordships now the constitutional autonomy of the state, which still was intact. It is important because that's what we're striving at. That please help us to maintain this constitutional autonomy. What has happened in the past, and also what kind of governments we'll have in future. It is for them to extend these laws to us. But we need our constitutional autonomy. Now, what is it that we had prior to 5th of August 2019? One, your lordship may have a look at this 1954 order, which is the basis of the order because all other orders have subsequently been amended. And I worked on that and I will show the kind of amendments made under various council orders from time to time.